Mr. Jackson, you now stand charged with another case. You were charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, yes. On January 18th, 2025, the officer observed the defendant's vehicle traveling 78 miles per hour in a 60 mile per hour zone, have an expired registration, and failed to maintain financial responsibility on Interstate 45. The officer noticed a prominent odor of marijuana trailing the defendant's vehicle, and a traffic stop was initiated.
Whoa, hold up. This is where it all starts to unravel. The officer says there was a cloud of smoke and a strong odor of marijuana. But here's the legal twist. Smell alone doesn't always equal probable cause. Courts have wrestled with this for years, especially since hemp became legal and smells almost identical to marijuana. So, was this a legitimate stop or a fishing expedition in progress?
The officer observed the defendant to be in the driver's seat with a black bag and a female to be in the front passenger seat. The defendant rolled down the passenger window, and the officer observed a cloud of smoke emitting from the vehicle with an odor of marijuana. The defendant was asked to step out of the vehicle with the black bag. The black bag was opened, and the officer observed a clear jar with a green leafy substance known to be marijuana based on training experience, along with a digital scale and individual baggies. The defendant was searched for weapons, and the officer found more packages of marijuana inside his private area. The weight of the marijuana was 1.82 ounces.
And Your Honor, if I could adjust probable cause.
Okay.
Your Honor, so while I don't dispute the reason for the stop here, I think there's a couple things that stand out. So there is a alleged smell of marijuana that comes from the vehicle, and then an alleged cloud of smoke that comes from the vehicle as the windows are open. So first off, the officer doesn't specify whether this is a cloud of course, burnt marijuana, which I would assume, or vaped marijuana, because those are two very different things with two very different distinct smells. Additionally, if the officer is pulling him out and looking for marijuana and he has this cloud, then he would be looking for burnt marijuana, right? So he would be looking for a roach. He would be looking for a blunt. What he does is he looks inside of a plastic bag. If we have embered marijuana or we have a lit blunt, it's certainly not going to be in a plastic bag without the smell of burning plastic. Additionally, the marijuana that is found in the bag is in a sealed glass jar container, something that would not emanate a smell because a glass jar is essentially smell proof. In this instance, I think we have an officer who went too far with the search, because we have Mr. Jackson here who did not admit to possessing marijuana, did not admit to this being marijuana. The statute, of course, requires that this has to be marijuana, and we know we have the issues, of course, with the hemp bill. But Your Honor, if you're not aware, you can go into any head shop, purchase flowered hemp, open it, and it smells, looks, everything about it is identical.
I understand,
to marijuana.
and that, yes, I agree with you for a beyond a reasonable doubt standard, but here, this is just mere probable cause, right? There's a good stop, goes to the car, smells marijuana, there's a plume of smoke that comes out. Not only that, Sean, he signed an affidavit that he wasn't going to drive. He's not supposed to be driving regardless.
And I get the driving aspect of it, but I don't see how a cloud of marijuana from burnt marijuana gets you inside of a plastic bag. At that point, it becomes a fishing.
Of that right there is the moment everything turns. You can hear the judge's disappointment, not anger, disappointment. Mr. Jackson broke a written promise not to drive, and in court, that's a serious breach of trust. Notice how the judge doesn't hesitate to revoke bond? That's a clear message to everyone. When you give your word in front of a court, it's binding. What do you think? Fair call or too harsh?
Expedition as opposed to looking for the actual contraband which he suspects that would be in the vehicle.
I don't know. I mean, I think that there's certainly enough to go forward. Beyond a reasonable doubt, I don't know. But this is just a probable cause standard, which is the low stand, So
I understand.
I'm going to find that there's probable cause to go forward with your case, Mr. Jackson. I ordered you not to drive. He's a driver in this car?
Yes, Judge.
Okay. I'm now revoking your bond. Goes with you. Sorry, Sean, but he promised us he's not going to drive. He signed an affidavit. He knows. He knew.
And Your Honor, will a new bond be set? And if so, can we get that amount set?
So I'll leave the first bond as is. first case, I'm going to do it at 5,001.
Okay. So first case, 5,001, and then the new case, of
I'll
course, would be
leave the
bonded out
first
as.
one or the second one as is though. So he's on bond for 2 cases. He's now picked up a 3rd case. Is this right?
That's correct, yes.
Mr. Jenkins, you now stand charged with the offense of reckless driving. You are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 12, 2025, at 6:26 p.m., the officer observed the defendant's vehicle traveling at a high rate of speed on a feeder road without headlights on. The officer checked the speedometer and it read 80 miles per hour while the defendant's vehicle was traveling faster. This occurred in a 50-mile-per-hour zone. The officer observed the defendant's vehicle make an unsafe lane change, cutting off a motor vehicle and reaching a speed of 106 miles per hour with moderate to heavy traffic. The officer observed another unsafe lane change while attempting to catch up to the defendant's vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. Does he have a valid Texas
Yes,
driver?
Judge, eligible.
I'm now revoking your bond on the other 2 cases. You will go into custody with me because you picked up a 3rd case, sir. Goes with you.
Judge, he also is wanting me off the case. So I didn't know if we wanted to
I
address that.
wanted to.
I'm not going to talk to you about this case. You have a lawyer. You need to talk to the
I wanted to talk
lawyer.
about my two cases before that, sir.
I'm not going to talk to you about this. We'll put you in back if you want. I can give you a new lawyer today.
Anybody?
I'll give you a lawyer, another. If you want to get off, and I'll provide you another lawyer. It's the 3rd case. Unacceptable.
Here today because you wanted to bond conditions.
Good morning, Mr. Barnes.
Sir, David, sir.
You made it out.
Yes, I did.
Just, we're not asking for much, man. Just be careful, behave. Don't do anything you shouldn't do, you know? Is those cases are still open in Fort Bend or what?
The current case is still open in Fort Bend. It's still pending. Your next court date is down there.
This on March, not all the cases are open.
One of them still open. Paul Two's representing him. I talked to Paul yesterday and it's set for sometime in March. I can't recall the exact
It's
date.
okay. Have we done PC on this yet or no?
We haven't done anything because he was in custody.
Right. Okay. So we're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. I just want to see if there's enough to go forward on your case. I don't know what happened. Okay, Alex,
Yes,
please.
Judge. On September 4th, 2024, the officer observed a hand-to-hand transaction between the driver of a parked vehicle and another individual. The defendant was a passenger in the vehicle, and the officer approached and smelled a strong odor of marijuana. The officer asked the defendant to step out of the vehicle and saw in plain view a scale in the driver's side door, and the officer detained the defendant and the driver. The officer found a bag of marijuana in the defendant's waistband pursuant to a pat-down, and the weight of the marijuana was 1.27 ounces.
Telling me he saw him do a hand-to-hand transaction or someone else?
The driver of the vehicle was a hand-to-hand transaction, and when he approached the vehicle, he asked the defendant and the driver who did a hand-to-hand transaction to exit. And furthermore, the officer smelled an odor of marijuana.
I know, but why would he search him?
What?
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
The only thing would be officer safety, just the pat down. That
All right, Mr. Barnes, I'm going to find no probable cause. Just be careful. All right? Really. You hang with dogs, what happens? No. You get fleet. Well, you can get bit too, right? Please,
Because a bad dog.
just don't hang out with the wrong people. All right?
Yes, sir.
Come on. Good morning, Mr. Huggins. So understand that your lawyer is here because he wants me to set you a bond. I don't know. I don't know anything about you. I've never met you before. I know that you're going to tell me it's little bunnies jumping in the woods, but really, what matters to me are 2 things. Number 1, what are you charged with? Are you a dangerous person? And more importantly, most importantly, are you going to go back to the demanding jurisdiction? I have no idea. We have to get to know you in the short time now, 20 seconds, just to see who you are. So, Mr. Kim, tell me about it.
Yes, Judge. Defendant is wanted at East Baton Rouge Parish, Louisiana for a domestic abuse, battery, strangulation, or equivalent of impeding breath. State would be opposed to bond. Defendant is currently on deferred adjudication for aggravated robbery, where he was the driver and there was a firearm involved. During the aggravated robbery deferred, he picked up a misdemeanor possession of marijuana, which alone, that wouldn't be sufficient to bring up the court. But the fact that one of his conditions on his deferred adjudication was to not consume any marijuana, he violated said provisions, and then now he picks up a strangulation. The warrant was 10 days old when he.
So this case here, this is a new case.
Yes, Judge, it was issued out January 14th. And so because of the repeated violations, the offense being one of them, the state would be opposed to bond.
If I may, Your Honor,
Please.
Mr. Huggins has already retained counsel for the New Orleans case. Eric Hayes, I have been in communication with him. I think it's important for the court to know, as it relates to the allegations out of Baton Rouge, that it was actually the complaining witness mother who hired us to be here this morning on behalf of Mr. Huggins. I also think it's important for the court to know, even though it is triable facts for the Louisiana case, she also sent us over several videos. We're confident that he will appear in New Orleans because he's already retained counsel. We believe that he won't have a problem complying with all of the things that's been outlined here in Harris County, seeing that he does have strong ties to the community and he is employed. And because of that, Your Honor, we do believe that there are conditions that can be put in place if the court elects to give him a bond, such as an ankle monitor, to ensure that, one, the court knows where he is and that the community is safe. And then also he has already retained counsel, Mr. Eric Hayes, for that matter out in Baton Rouge. So I believe I have no reason to believe he won't answer to Baton Rouge, and I don't have any reason to believe he won't comport with the conditions here in Harris.
You're a dangerous person, man. How old is he? 22, 23?
Yes, Judge. And to add, for what it's worth, he already had a GPS ankle monitor as a condition of his deferred when the strangulation happened, or at least according to the conditions. And
Was he not supposed to go there too?
No, it's just one of the arguments made by counsel was to have a GPS monitor secure.
This is that, it's such a short time. He's picked up this case.
This one hits hard. The judge straight up says, "You scare me." That's not something you hear often in open court. From a legal standpoint, it shows just how much weight a defendant's history carries, not just the new charges, but the whole pattern. Even though his lawyer made strong arguments about family support and legal counsel, the prior violent offenses tipped the scale. Here's the question. Should judges lean on instinct when deciding bond or stick strictly to the record?
Picked up, I guess, a weed case, and he's on probation for an aggravated robbery. I mean, really.
Full disclosure, there was a motion to adjudicate, but in the Brenham case that was dismissed. I don't have the files for the Brenham one, but I presume because the deferred was cured that they didn't pursue it. But he was only charged and it was later dismissed, but it was 2023. So obviously very recent.
Let me ask you this. Is he on bond for did they file a motion to adjudicate on the
aggravated robbery, but then that was dismissed on October 16th.
So he has no holds now, right?
Currently,
No,
yes, Judge.
And it was dismissed because the Brenham marijuana case was ultimately dismissed.
Yes.
I'm not comfortable giving you a bond now, Mr. Huggins. I think you're a dangerous person, man. You picked up that case over there. You're on probation for an aggravated robbery where there's a gun, and I don't know if there's shooting involved, but the good news is that it's only Louisiana. We have buses coming in and out probably 2 times a week to take people back because we have so many people from Louisiana here. So once you waive extradition, Monday, Tuesday, you'll be back in Louisiana. So he's not going to be sitting for not too long. I don't feel comfortable doing it, man. You scare me, dude. So you said he has waived, right?
Yes, Judge.
Sorry, counsel. But the good news is that he'll be back lickety split, in was it Lafayette?
It's East Baton Rouge,
East Baton Rouge.
Currently the aggravated robbery doesn't have a new MAJ based on the impeding or the strangulation, and so I can't speak for the trial bureau, but if they decide to revoke.
So Huggin, you got to understand, when you're on felony probation, something like that, you got to live with a halo on your head because you could be looking at 20 years, man. All right.
Thank
Thanks.
you, Your Honor.
Thank you, Judge.
Thank you.
Yes, sir. Ma'am, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On January 16th, 2025, at approximately 10:25 p.m., the officer was traveling on East Sam Houston Tollway and observed the vehicle traveling at a high rate of speed, overtaking other motorists and changing lanes without signaling. The officer observed the vehicle get on Ship Channel Toll Bridge and pace the vehicle at 75 miles per hour in a 50 mile per hour zone. The vehicle further failed to drive in a single lane and a traffic stop was initiated. The officer made contact with the defendant, the driver of the vehicle, and observed the defendant to have slurred speech and odor of an alcoholic beverage. Standard filtered righted tests were conducted, HGN 6 out of 6. walk and turn 5 out of 8, one leg stand 2 out of 4. The defendant was read the DIC and refused to provide a specimen, and a blood search warrant was signed and executed.
Ma'am, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming anything of this nature, I'm going to revoke your bond, put you in jail. Do you understand, ma'am?
There's no driver's license on file for the defendant.
Okay. Any prior DWIs?
No priors, Your Honor.
Okay. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I take it extremely serious. You just saw what happened. If you don't have a license and insurance, do not drive. Would you like to apply for a court-appointed lawyer, ma'am? Okay. What's going to happen now is I will have you swear to it that you're not going to drive without those 2 documents. I will have you sign a receipt with Victoria. We will have you get with Fleischer at some point for your bond conditions. In the meantime, we'll have you fill out an application, then I'll have you speak to a lawyer here momentarily. All right? Please. And then if you could give her an application. Mr. Leary, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, at approximately 12:51 a.m., the officer on-viewed 2 vehicles at the block of Tomball Parkway, blocking the moving lane of traffic. The officer observed a white Jeep and an orange Corvette line up directly next to each other side by side, and the vehicles accelerated at the same time at a high rate of speed. The traffic stop was initiated of the white Jeep, and the officer made contact with the defendant, the driver, who gave his name and was identified by his Texas driver's license. The other officer stopped the Corvette and detained the second defendant. The driver was positively ID'd by the Texas driver's license.
Know how fast they were going?
Your Honor, they do not specify in the DIMS.
Okay. Mr. Leary, I'm going to find that there's probable cause to go forward with your case. Have you run his license, see if he has it?
Eligible, Your Honor.
Okay. I'm ordering you as a condition of your bond not to participate in this kind of behavior again. If I see that you do, the first thing I'm going to do is I'm going to revoke your bond, put you in jail. The next thing I'm doing, I will take your privilege to drive away from you permanently. Do you understand while this case is over?
Yes, sir.
Open. The ability to not drive in Houston blows. Trust me. Do you understand?
Yes, sir.
Now, you have a lawyer. It's your responsibility to stay in touch with Mr. Clay, and he'll tell you when you have to come back to court. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you when you have to come back to court. You pick up a new case, you endanger my public. I only have one place for you. You understand?
Yes, sir.
All right. So I'm going to have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go.
Have the excuse.
Yes, sir. Thanks. It's come to my attention that you've picked up a couple new cases while you're on bond. So state's asking me, or I guess, what are you asking for, state?
We were asking for 5,000 on each of the cases.
To revoke the bonds?
Yes, sir.
On which cases?
On, one moment,
Mischief.
the criminal mischief and the assault bodily injury.
And that is because he has picked up a new criminal trespass.
Yes, sir.
Did you say that there was one that you were going to have indicted too?
Yes, sir. And we're pending on the offense report for that still at this time. So we're waiting for a new date.
What is that?
What is that case?
Yeah, what is that? Is it another trespass? Is it a theft?
Assault bodily injury.
Oh, there's another assault.
Yes, sir.
Did you know about this?
Yes, because that one was no PC by the magistrate when all of these cases came to the court. But it was no PC because they, I think, fat fingered the date of the offense as 2021, not 2024. And so it was outside the statute of limitations when it went before the
Someone
magistrate.
accidentally put 2021 on the actual report instead of
And
24.
Yes, my understanding is that the state is having to get a copy of the offense report and then they can take it to the grand jury with the correct date.
Okay. So what is your response as far as the mischief and the assault on the bond revocation?
We're in agreement with the 5,000
Okay.
He has a case upstairs, so.
Oh, I see. Right. You have a felony case. So, all right. So on the mischief and then the assault, if we can put it at now 1, 2.
Judge Jackson had previously revoked the ABI when they were last week.
Yeah, but I think they're all in agreement. So we'll do 5,000 and 2, 4.
5,001.
Yeah, on the assault and the mischief. Right. We'll leave the trespass as is. Right. So Mr. Rodriguez, what's happening now is I'm going to revoke the bond on your 2 older cases due to the fact that you continue to pick up other new cases. You can't expect. Right. So,
Just for clarification, the case that's being taken to the grand jury, that's already kind of accounted for in the 5,000. There's not going to be a new BVR when that.
right.
Okay,
What do you,
I'll defer to you on that, Your Honor.
okay.
okay.
I'm okay with that.
Okay.
Right. I'm not going to just be duplicitous to kind of just then revoke it again.
Okay, I just want to make sure we're all on the same
So
page.
what do we set it at when we actually do get it?
The ABI,
Yeah, the new one.
To be completely candid, Judge, I don't know that it really matters because 1,000 or 11 billion, 1,000, it's.
Yeah, I guess we'll cross that bridge when we get there, whenever they do get it done. Yeah, okay. All right, so if you do bond out, I'm going to put a GPS monitor. I don't know if you're going to get out or not, but I'm ordering you not to have any contact with the complaining witnesses in these cases, not to be in possession of weapons, and I'm going to put a monitor on you so I know that you're not going over there. The monitor will go on you prior to your release from custody if you are able to make bond. Do you understand? Do you have any questions? Okay, man. Good luck, Mr. Rodriguez. So we need him to sign before he goes, please.
Thank you.
Thanks, guys.
I'd be excused.
Yes.
Just come over here, Mr. Rodriguez.
So I will, Kelsey, I'm going to grant the motion that you did in the queue, the motions that you filed, I'll grant them.
Thank you, sir.
Okay. Are you ready? Okay. Yes, ma'am. I already done it. So what I'm going to do, just unset term. Yeah, he's a big boy. He knows. We're done. Doesn't want the help. We'll just unset term and then he's just free to go. So just, nope, just admonish him if he picks up another case. Thank you. Yes, ma'am. Mr. Butler. Yes, I'm ready.
Really Hassan that's on the dock.
You've been so patient.
What's that?
You've been so patient.
Yeah, well, I had some rounds to make this morning.
Hassan.
Yes, Hassan. She's here from California. So what happens is she's on PTI. We get notification that there's violation. We hadn't pulled any of the stuff to really take a look at it. She's given me.
You've not seen what the violations are?
I'm sorry?
You've not seen the violations?
No. I've seen like the kind of the blanket thing where they allege the usual, like a blow, something like that, or a misty blow.
Ms. Hassan, come up.
And so what we're going to request is obviously a reset to be able to speak to the appropriate person. Ms. Geis, I believe, is in charge. Right.
Has she already been booted out?
No, this is the initial, they always,
If everything didn't happen over the PTR program, she would. But because I guess everybody is in limbo, they're just waiting.
What violations do we have?
218 is a lot. She's averaging 14 to 34 skip tests a month on her device. She tested positive for THC. She failed to report for her office visits on the September 24th, October 8th, December 3rd, December 31st, and January 8th.
Can I?
Nope.
so obviously.
Actions speak.
Yeah,
Right.
but Your
Stop,
Honor.
stop. Don't. Got a lawyer.
I'm so passionate about this. If I could, Judge, we would just request a reset. Let me get all the.
So, but I'm now going to put an ankle monitor on her so I know that she's not consuming. I'll pay for it.
Did you fly here?
I did fly.
Is she on and everything like that?
I would assume so. But I mean, she's on bond in this court. She's skipping tests that she's not supposed to be doing. I'm putting a scram monitor on you. That's it.
I do have an answer.
Guys, you talk
Yeah.
over there. You're on bond in this court.
Okay. And I will travel as well with the monitor, but I did have an issue last time I came with the DUI machine. It stopped working because I traveled out of state and I was ordered to pay a whole new device, turn it in, and I had to wait a whole week without testing because of that problem. So I just don't want to run into that same problem with the ankle monitor.
So when you have issues,
Mhm.
you're supposed to contact the provider immediately and let them know, hey, I've got an issue. You go to where they are, right? And there are devices that you can, they're global. You can go all over the globe. They use, Wi-Fi or whatnot, so that it doesn't matter where you are. You can be in Abu Dhabi. You're still able to use the device, and the device can go internationally. There's just, if you know that that's a lifestyle you have, that's the kind of machine that you get. So regardless, I mean, I'll give you, the case is 400 days. I will give you some time, right? Tell me, how much time do you want?
I don't know, like 3 or so weeks, or
Done.
because everything else in the way. But and then can we wait for appearance the next setting?
I don't know yet, because if they deny it, then we need to figure out what we're gonna do.
Figure something out. Yeah.
So,
Like she and I haven't really had the time to sit down and just really go through, like obviously she's very passionate about what happened and.
so amending your bond conditions, you will get a scram ankle monitor now. If I find that you're consuming alcohol, and I don't care what it is, I don't care if it's mouthwash, I don't care if it's a tequila lollipop, I'm gonna revoke your bond. Do you understand?
Yeah.
Can you run her license to see if she has a license?
Yes, Judge, I'll run it right now.
Today,
At what time?
later in the evening, like around 6, 7.
So Judge, her flight leaves today at 6 p.m.
She's gonna go now. We'll get her in now.
Get it done
Right now.
Okay, right.
Your Honor, it appears to be a valid California license.
As long as you have a valid license and liability insurance, then you can drive unless, well, no, you're not allowed to drive without an interlock. So you have to have the interlock.
I'm not driving right now.
I'm just telling you what
Okay.
the expectation is, so that, I don't want to have to revoke your bond. You have to know what the expectations are. Now, okay, so we'll give you whatever time you want at the next setting. Because your case is old and because of their violations, I'm not waiving your appearance anymore. If you get her back in to the program, I guess at that point, we don't leave her here, right? I'll waive it. But if it's denied, then she's got to come back here so we can resolve it one way or the other.
Okay, I'll just find a new board.
Just let me know. Yeah. Okay. All right, man. Good luck. Fair, you are charged with assault bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 3rd, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. Upon arrival, the officer met with the complainant, who knew the defendant as his sister-in-law. The complainant stated the defendant came to his residence shortly after a verbal dispute with his child's mother, and the defendant arrived and told the defendant told the complainant to come outside and meet with her boyfriend. When the complainant stepped outside, he was assaulted by the defendant by a closed fist to the back of the head. The complainant stated the defendant continued to strike him in the back of the head before he began stumbling down the stairs. The complainant was then assaulted by an unidentified black male while still being assaulted by the defendant and the defendant's sister. The defendant was gone on arrival, but was contacted via a public service by the officer and was ordered to return to the location.
Did the other person get arrested as well?
It appears there is a connected case, Your Honor.
The sister was also arrested.
So we have 3 co-defendants or
No,
2
just
co-defendants?
Yeah, just the sister, Your Honor.
We know of alcohol or any kind of,
There's no allegations, Your Honor.
I see that she's on probation as well. Ms. Fair, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you not to be in possession of weapons, not to have contact with the complaining witness in this case, and not to be in contact with any of the co-defendants. Do you understand? Yes? Okay, if I find that you violate these conditions, I'm going to revoke your bond. I'm going to put you in jail. I'm going to protect my community at all costs. You understand, ma'am? You need a lawyer, ma'am. Okay, Ms. Fair, I need you to fill out an application for me. I'll provide you a lawyer after that. Don't violate these conditions. Do you understand, ma'am? Okay, please. We'll have you sign a reset. You'll get with Fleischer for your bond conditions, and then we'll have you fill out an application.
I spoke with the complainant and
Ma'am, hold on. Come back up.
he's no longer living, he still has the lease to the residents of the 1180 Grant Road, but he's not living there anymore because the co-defendant lives there. He's actually living at his sister's residence, so if we could get a restriction, like a.
Sure, just provide it to Felicia so she knows, and then we'll put that in the order as well that she's not to go to this location.
Yeah, Judge.
Okay, okay, ma'am, please.